history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Welcome to the Transparency Tuesday, the noon hour here on Eastern Standard Divisions Time.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you?
Change something. Welcome. All right, I'm here for it. Let's go. First of all, before we get started, I want to remind everybody in the beginning, we're going to take a look at a couple documents. The first being Brian Koberger's, let's go ahead here. Hector's got something for us. There we go. You guys remember this? The charging. If this is going to do this, hold on one second. Is it glitching on your guys' side, or is it streaming okay? All right, so you guys remember this? Brian Koberger went ahead and he had to initial his rights, but then we got to the second page, and Brian Koberger left some blanks. If you guys remember, when the question was, has anyone made you any promises or coerced you to act in this manner? First of all, you guys remember that? And he didn't check either box. Okay. Then please choose only one of the following options to indicate how you wish to be represented in this matter. And there was two boxes that he left open, which was, I wish to be given a continuance to decide how I would like to be represented. And then no checks. And then the second question there is, I wish to retain / hire my own attorney. Again, left blank. So in case you guys, maybe new to the case, but this was right off the rip where Brian had to, this is filed. I think this took place the 5th of January. Now, do you guys remember that Bill Thompson, in connection with this case, had to fill out an affidavit? You guys recall that? Well, before I show that affidavit, this is what was filed on the 3rd of January when this, after his arrest. And this was the non-dissemination order, okay? And they stipulated to the fact that prohibiting attorneys, investigators, and law enforcement personnel from making any, extrajudicial statement, written or oral, concerning this case. You guys remember that? Okay. Then they wanted some clarification on the non-dissemination order, specifically the Gonsalves with Shannon Gray, all of that. In then February of 2023, in comes, this is the affidavit that Bill Thompson had to file. And it was done at the office of the chief civil deputy prosecuting attorney. So a civil. All right. And in this, the third thing here, the members of the Gonsalves family who are represented by Mr. Shannon Gray are potential witnesses in this case, including at trial and or sentencing. Okay. You guys recall that? And then, then this is where Shannon Gray was present in the courtroom, and they wanted clarification on the non-dissemination order and everything to do with that. And Shannon Gray then had a memorandum in support of the motion to unseal the court record regarding conflict issues of defense counsel. So I don't know if you guys recall this, but remember what seemed like the media was pushing. So I want us to go back and to think about all of this now, where we thought, like, you know, why is the media pushing so hard to talk about Kara Kernoodle? All right. And, you know, Ashley Banfield's doing all these episodes. And Ashley Banfield was, I mean, straight up going ham on Ann Taylor. Do you guys remember that stuff? Okay. Well, I want to remind everybody where this came from. This was put in, memorandum in support. And this is, I, Shannon Gray, am an attorney licensed in the state of Idaho. I represent victim Kaylee Gonsalves' family in the above referenced matter. Okay. And this is, he was making a memorandum in support of the motion to unseal the court record regarding conflict issues of defense counsel. They wanted Ann Taylor off this case. Okay. And now, knowing what I know now versus then, it made it seem like mainstream media was chopping off the head of Ann Taylor, right? And I'm just like, what the hell is going on around here? Like, damn, Ashley Banfield. Like, you guys can go back and watch my episodes about it. I'm just like, whoa. So the court held a hearing regarding conflict issues of defense counsel Ann Taylor on January 27, 2023. The parties present were defense counsel and Ashley Jennings was representing the Latah County Prosecutor's Office. I am not aware of any other counsel that was present at the hearing. I am also not aware that anyone other than the parties mentioned above were even notified of the hearing on this matter. Okay, and the reason he says this about being notified is you will see when we talk about something here in a minute. The Gonsalves family and I only became aware that there was a hearing on this matter from a meeting with the Latah County Prosecutor's Office and investigators on February 8th, 2023, or we would have never known such hearing took place. Okay. They want to know what happened. So the argument is since the record has been sealed regarding the conflict issues regarding defense counsel Ann Taylor on this matter, and the fact that the Latah County Prosecutor's Office did not offer any objections or evidence at the time of the hearing, we will presume there is a minimal record of findings and conclusions. It is also my understanding that there were no witnesses called during the hearing and no other outside testimony was given to the court other than that of defense counsel Ann Taylor. In determining whether to seal the record of the hearing on the conflict issues of defense counsel Ann Taylor, the court would have to have analyzed and then Idaho code. Okay. Conflict issues in this case would involve Miss Taylor's ability to represent Mr. Kohlberger after previously representing Kara Kernoodle, the mother of one of the victims in this case, Xana. Okay, you guys remembering this? I'm jogging your guys' memory, hopefully. As well as any other actual or potential conflicts with any other clients. In addition, the court would have had to address any issues regarding why Miss Taylor withdrew from Kara Kernoodle's representation as a current client in order to take on Mr. Kohlberger. Okay, do you guys remember this? This would include if there was, I'm sorry, this would include if there had been a waiver filed by, like they wanted to know everything about this, okay? If there was a waiver filed by Kara Canoodle and or possibly eliciting testimony from Kara Canoodle to determine the extent of any contact and information related to Miss Taylor during the representation. Do you remember this is the time period when Ashley Banfield somehow had a woman, Kara Canoodle, who is literally on a warrant, like she is wanted. And during this wanting phase, I said, wow, who the heck? Who's Ashley Banfield? Man, she's got some sources. How the heck did she get Kara Canoodle to come out and do an interview from her car while she is wanted in a state? You guys remember that? Well, now I know who the source was and how that was all set up. I truly gave it no, like, I was like, mainstream media is just on a witch hunt. You know what I mean? But how would they possibly? Why did Kara Canoodle ever talk to News Nation? Okay. Who got Kara Canoodle to talk to News Nation? Now, that's when Kara Canoodle made some wow claims, okay? Like saying that Ann Taylor was power of attorney over her. Do you guys remember that? And I'm like, wait, what? She didn't even, what are you talking about? Okay. You guys remember Kara Canoodle saying the stuff that she said? And then Ashley Banfield, man, was just running with this shit. Running with it. Okay. So now, additionally, the court should have considered the potential for a conflict to arise at different stages of the criminal proceedings based on Ms. Taylor's prior representation of any witnesses or parties involved in this matter. Do you understand that that would mean that there would be a conflict of interest to any public defender that would take a case? I'm just saying, think about that. Think about all the drug shit that the public defender's office gets. And, oh, you represented him. Well, yeah, I'm the public defender. Like, the public defender's office wouldn't be able to defend anybody then. Just think about that. Upon gathering this information, the court should have first determined whether the scaling the record of the conflict hearing is consistent with openness and public policy, right? Secondly, the court should have determined whether sealing the record of the conflict hearing is consistent with the type of hearing being historically been open to the press and general public. Again, so think about this. Ready? Who stipulated to this? It wasn't like Ann Taylor just was like, oh, I want this closed and it's closed. No. It was stipulated to. You know what that means, guys? That means both sides agreed. All right. So here, well, I'll come back to it, but both sides, there is no, like the prosecutor's office, right? They could have been like, no, we want, like, this can be an open hearing, but stipulating to something and saying, okay, it's going to be closed. That would have been a decision made by the prosecutor's office, just as much as it would have been made by the defense. So just so everybody understands that. So secondly, the court should have determined whether sealing the record of the conflict hearing is consistent with this type of hearing. Finally, the court would need to have applied ICAR 32I and make a finding of fact regarding the applicable issue and fashion the least restrictive exception consistent with privacy interests. All right, because so the G's wanted this, they want to know what the hell happened in that hearing. All right. Taking into consideration the information the court reviewed in this case, which was merely defense counsel and Taylor's testimony to the court. Again, how they just think that is interesting. Because if it's a sealed, if it was a sealed hearing, how do you know who was in there and who wasn't? So taking into consideration the information the court reviewed, that means telling me that you think that you know that. The scope of the information obtained by the court from Ms. Taylor and the lack of any findings on this matter, the court must unseal the court record regarding the conflict issues with defense counsel. So I want everybody to understand that right from jump, the Gonsalves family did not want Ann Taylor representing Brian Koberger. They had a problem with it. A problem with it. And I'm curious as to why. Because anybody that knows who a public defender is, your name gets attached to everything on the top of it. For example, when Ann Taylor ended up taking on, this case, her office, so her name is stamped on everything, and would have to redo a whole bunch of cases and assign them other places, or bring in people that actually have private practices that also put their, their hat in the bid for okay, I will also public defend. And usually the people that do that are the ones that don't make enough money and that they need to take on cases like that because the state pays them. It's not like they're doing it pro bono. No, they're just getting paid the hourly fee, which is going to be considerably less than them applying it to a private practice, being able to say, here, I'm going to charge you $300 an hour. Whereas, okay, if I'm taking on a drug case with the public defender's office, they're going to pay me $1.80 an hour. All right. But the reason lawyers that are private practice take those on is because they're not busy enough and they need the money. Let's be real. So make this a little bigger. So they didn't want Ann Taylor on this case, and they wanted this. They wanted to know everything about this, and then what took place. So, but hold on one second. I want to show you guys. In applying the above consideration, it is not common to seal records regarding conflict issues of attorneys. At this stage of the criminal proceeding, conflict issues should be open to the public. This avoids any actual or potential conflicts the court may not be aware of and helps ensure any actual or potential conflicts may be avoided. By opening the record to the public, the court can fully analyze all the conflicts, not just these recognized by defense. Then the number of witnesses and the scope of this case is massive. And the possibility of other conflicts regarding defense counsel should be thoroughly investigated. Okay. Should be thoroughly investigated. In applying ICAR 32I, the court must have made a determination that the record of the conflict issues contained one or more of the following. Number one, highly intimate facts or statements, the publication of would be highly objectionable to a reasonable person, or the record contains facts or statements that the court finds might be libelous. Number three, the court record contains facts of statements that may compromise financial security. I mean, this is all from the statute. Number four, or I'm sorry, number 3, the record contains facts or statements that may compromise financial security or economic or financial loss to a party having an interest in the proceeding. We're going to circle that one. Okay. And number 4, the record contains facts or statements that might threaten or endanger the life of the safety of individuals. Number 5, the sealing of the record is necessary to preserve the right to a fair trial. Or 6, the record contains personal data identifiers that should have been redacted. So, in order to, they're basically saying, in order to seal this, like you would have had to find that something here is there. Otherwise, this should not be sealed. All right. Now, Shannon Gray then continues to say, I cannot see any fact pattern applying the above determinations that would justify the court sealing the records of the conflict matter in this case. It appears the only testimony given at the hearing was Ms. Taylor's. Additionally, the Latah County Prosecutor's Office failed to do any due diligence. Now watch this. Ready? Failed to do any due diligence prior to the hearing regarding any conflicts and failed to inquire or object at the time of the hearing to clarify or identify any actual or potential conflicts. All right. Do you know what the word due diligence means? Basically, is another word for inept, you guys. Your due diligence. So here, Shannon Gray is calling out the prosecutor's office. All right. That you guys aren't doing your job. You didn't do your job. Like, what the hell? Right. And just to remind everybody when this was written, 2/27/2023. All right, this is really important. Follow along this timeline. All right. So the proper remedy for the court, if they believed that protected information had been provided, would have been to redact the information and then provide the full record to the public. Have you guys seen that full record yet? So this is back February of 2023, at the end of the month. Okay, right before March comes, where a lot of heavy hitting is about to take place in this case, with the major heavy hitting of Richard Batante's affidavit saying, we need to talk to Bethany at the preliminary hearing. Okay. So this has never surfaced, right? Here, Shannon Gray calling out hardcore. Additionally, the Latah County Prosecutor's Office failed to do any due diligence. Like, we should have had Ann Taylor off this case from jump. You guys aren't doing your job. We're over here trying to figure out ways to make that happen. And you guys are not following suit, right? So now think about this. So what happens then? Go pull up the dates when Ashley Banfield decides to interview Kara Canoodle, right? And Kara Canoodle's like, basically, how did you have that hearing without having Kara Canoodle there, right? Well, because Kara Canoodle is wanted on a warrant, right? Like, where's Kara? We don't know. Kara's, she didn't show up. She's wanted on a warrant. But then guess who gets Kara Canoodle in an interview? Ashley Banfield. How did that happen? Well, I have a pretty good idea of how that happened. Now, so then, the reason I went ahead and pulled up the Idaho Select Victims' Rights manual, which is 68 pages. It's very informative. Very informative. And I'm going to jump right here to something that's interesting, because I have said it, I said, wow, the advocacy has kind of changed from, it's like, hey, we want the truth. We want to know what happened. We're still leaving it open that Brian Kohlberg could potentially be, innocent. This whole innocent until proven guilty, but we want the truth, and we're here advocating for our daughter, and then Maddie, who's like a second daughter to them. But I'm going to tell you guys something that in this Idaho handbook or manual, whatever you want to call it, I came across something I think is interesting. And with this case, or any case, it breaks down that you have the right to confer, you have rights to due process, fairness, dignity, respect. This is why all of you guys out there that are doing, talking points about your theories that are, think twice, right to be heard, right to information, right to notice, right to be present. This is what I was looking up. Right to be present. Can Idaho pay for you to go to a hearing, a trial? Can they fit the bill? Hey, this was supposed to be in Latah County. Now all of a sudden it's moving. Okay. It's moving to Boise. Well, holy shit. We're victims. We have the right to be heard, but we have the right to be there. Right. Okay. So that's kind of the reason I went and started looking into this manual. But we're going to come back to this, but I want to talk about right here, which is the right to refuse interviews, ex parte contact. Remember when they had a sign? Remember when you could go on the Idaho case of interests? And when you go under Brian Kohlberg, you'd be able to see there was a time when they were posting about what victims signed and filled out all the right paperwork to be considered a victim, to all of these things. That they're listing right here. You guys remember that? When you'd be able to go on the Idaho case of interest, and you'd have been able to see who. Remember, we were all trying to because the names were redacted to the point of there was just a first initial and a last initial, or I'm sorry, a first initial of both the first and last name. There, I said it wrong the first time. You guys remember that? And everybody was trying to figure out, okay, who, what, this is why, if you're, a victim. But remember, there were some people that we thought were missing from that list. And there could be reasons that they were missing. Because how am I supposed to contact, for someone like Kara Canoodle? She was a fugitive, basically. How is she supposed to do this, but then be out on a warrant? So I'm just trying to get you guys to remember when this had to be filled out. It's in the beginning. We'll go on that interest case page and see if you can find that. See if it's still there. As I don't think it is. All right. Now, I then said, well, what does this handy dandy thing talk about? It talks about a lot of stuff, but I'm going to go to page right here. Okay. So for everybody to understand, victims' rights apply to family members of homicide victims. Okay. And victims' rights do not authorize a court to dismiss a case, to set aside a finding of guilty or acceptance of a guilty plea, to obtain relief from judgment. But hang tight. Victims' rights to restitution. I read through that. Okay, I'm going to come back to that. And then I said, okay, there's 13. Let's see. The court may, with the consent of the parties, order restitution to victims and or any other person or entity for economic loss or injury for crimes which are not adjudicated or are not before the court. And I said, can the University of Idaho be an entity that is a victim? Okay. Well, but I think that that book that they went ahead and published to say that attendance was up or didn't have moved. So that'll be interesting. Did you guys know that every pre-sentence report shall include a full statement of economic losses suffered by the victim or victims of the defendant's crime or crimes? And then you as a victim get to talk to that investigator of the pre-sentence report. You get to see that pre-sentence report. There's just very interesting things that you actually can, like your rights. So then I continue to read, and then I want to talk. Again, I'm going to come back to this. And I said, okay, here we go. The court may impose additional fines against defendant convicted of certain felonies, and under that is obviously murder. Okay. Now, now I think I realize why somebody on YouTube lost their YouTube channel. But I'll zoom in here. For the record, guys, you cannot, okay? All people or entities who contract, keyword there, contract, with an accused or a convicted person or their representative regarding a reenactment of or to share any information regarding the crime to pay money to the state treasurer instead. State treasurer then will deposit the money in an escrow account, because we're then going to see what ends up happening. Because why? Because every person, firm, corporation, partnership, association, or other legal entity contracting with any person or the representative or assignee of any person accused of a crime to the state with the respect to the reenactment of such a crime by way of a movie, a book, magazine, article, radio, or television presentation, live entertainment of any kind, or from the expression of such person's thoughts, feelings, opinions, or emotions regarding such crime, shall pay over to the state treasurer any monies which would otherwise, by terms of such contract, be owing to the person so convicted, when they get convicted. But if you are accused of a crime, but you don't actually become convicted, you are acquitted, let's say, you can then have that money. All right. So and there's ways that this is handled. All right. The state treasurer, at least once every 6 months for the next 5 years from the date it receives such money, shall cause to have published a legal notice, because guess who's entitled to that money? All the victims. Okay. And they must publish it in a newspaper to say, hey, we have this money in escrow, you're entitled to it, blah, 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 blah. So I continued to read, and upon disposition of charges favorable to any person accused of committing a crime, you then have the ability to go and get your money that's in this escrow account. Okay. Now, There is another way that you can get this money, even if you are convicted. And you have to show that it's going for the purpose of retaining legal representation at any stage of the proceedings against such a person, including the appeals process. So this is a way that you can, as an accused person and a potentially convicted person, if you can prove and show that you're going to be using the funds for this reason, then you are entitled to that money. Okay. Just showing you guys some things. Now, for anybody that's trying to be creative out there, an accused person cannot go and get and file for like an LLC. Okay. And then it'd be like they're working together with your own LLC. And then that's how you're going to be able to get your money. Like, you can't do that. So that's this clause here. So that can't happen. Now, again, you have to be contracted with somebody that's an accused person of an alleged crime, and then be doing those things. And then that person that you contracted with is receiving funds. That's actually not allowed, and the victims would be entitled to that money. Or you have to show that you're using the money for the purpose to obtain counsel. All right. So, but now let's go to something that I was like, holy balls. And that would be page 47. And it's called, I'm sorry, it starts on 46. Crime victims' right to apply for compensation. Listen up, folks. This is what you're here for. Crime victims' right to apply for compensation. This is Idaho's, it was revised December 2023. An applicant for an award of compensation may apply in writing in a form that conforms substantially to that prescribed by the commission. So this is how this works, is that Idaho, according, and then you could look up if you want to, if you don't believe me, click on that. It is a claim to be filed within 1 year after the criminal conduct occurred. So you only have 1 year to put this claim in. So that would be no later than November 13th, 2023. All right. And compensation may not be awarded unless the claim is filed with the commission within 1 year after the day of the criminally injurious conduct occurred, causing the injury or death upon which the claim is based. So you, so you have to do this within a year. If you don't, you cannot, you know. So you guys remember when everybody thought that Steve Gonsalves, hey, like he put in that he put a clause that he could potentially sue the police or whatever. Well, looking back at things after I'm about to flip the page to show you guys something. Ready? By the way, if Dylan and Bethany would have waited until 72 hours after the crime, nobody would be able to be doing this. So, but here it is. If you, number four, this is why you're here. In order to be entitled to benefits under this chapter, a claimant must fully cooperate with all law enforcement agencies and prosecuting attorneys in the apprehension and prosecution of the offender causing the criminally injurious conduct. Let me repeat that. In order to be entitled to the benefits under this chapter, a claimant must fully cooperate with all law enforcement agencies, with the big daddy here, and the prosecuting attorney. That means our man's Brian Kohlberger. Guess who your man is? Brian motherfucking Kohlberger. And if you ain't backing us on that, you aren't getting shit. Okay? When I read this, I said, holy shit, when do I feel like everything changed? When was this claim, as a victim, you have your attorney, they're going to do things for you. And you have a victim's right advocate. You do everything with them. And they tell you about when deadlines are, they tell you how to file, they tell you just everything. They help you do it. Shit, if you have a lawyer, they're going to do it for you. Okay. But if you do not cooperate, and if you think you're going to be running all around and saying whatever the hell you want, okay. Well, we'll see how that pans out based on all of this. When I read this, I said to myself, holy shit. Could this be the reason that Steve did a 180? I'm not saying it is. I'm not saying it isn't. I'm asking the question. I'm saying, holy shit, is this why, that I've personally seen such a drastic change in, language, why we can't be too critical of the prosecutor. So again, the commission, upon finding that the claimant or victim has not fully cooperated with appropriate law enforcement agencies or the prosecuting attorneys, may deny or reconsider and reduce an award of compensation. Now, your compensation you're applying when you're doing this whole compensation part, this claim, subject to the limitations on payments for the costs of forensic and medical examinations of alleged victims. Like, that's not what we're talking about. Compensation benefits to be awarded if claimant meets preponderance of the evidence standard. You know what so it's just the preponderance of the evidence. It's not beyond like a reasonable doubt or anything like that. And compensation award does not require prosecution or conviction. The commission shall award compensation benefits under this chapter if satisfied by a preponderance of the evidence that the requirements for compensation have been met. And 100% this family would be meeting that. An award may be made whether or not any person is prosecuted or convicted. Proof of conviction of a person whose acts give rise to a claim is conclusive evidence that the crime was committed unless an application for rehearing, or an appeal of the conviction is pending, or a rehearing or new trial has been ordered. The commission may suspend the proceedings pending disposition of a criminal prosecution that has been commenced or is imminent, and may make a tentative award under section. So everything always has, it could, again, there's numerous statutory provisions dealing, among other things, what types of expenses are. So let me just, everybody. So there are statutory provisions, but among other things, it's what types of expenses and how and when a victim may apply. Okay. Again, this is under the victim's right to file compensation claim. In addition to compensation award, attorney fees may be paid for the representing claimants before the commission. Amount of attorney fees may not be in excess of 5% of the amount paid to a claimant or his behalf paid indirectly to a claimant's attorney. You guys see that? Shannon Gray, you got some interest in this now. Shannon Gray, welcome. You got some interest. You got some, so. In Idaho, a claim to be filed within 1 year after the criminal conduct occurred. Cooperation with investigation and prosecution is required. Exceptions for good cause shown. Good cause shown, though, you could go against them. All right. But that's just a hell of a lot more work. Let me just, this is our guy. Shit, I'm going to wear a damn shirt that says, let's shoot this motherfucker. All right. That's how much I'm backing you, But if you go against us, though, there's ways that, hey, you were not cooperative. So again, think about this in the beginning. So this is why I said there's going to be a reason that I brought this out, because February 27th, 2023, they didn't file anything probably yet. Okay. And it's when Shannon Gray is saying, dude, the Latah County Prosecutor's Office failed to do any due diligence. Okay. That's a huge ass. Like, you want to know what you're accusing them of? That's when attorneys are accusing other attorneys of due diligence. That's a professional code. Yeah. Your oath, like, damn, right? So again, this was back, like I said, February 27th, 2023. Oh, and I want to show you guys that the victims have the right to there we go. Victim's right to communicate with the prosecution. A crime victim, as defined by statute, has the right to communicate with the prosecution. And it was happening. As it was said right here in this letter, that the Gonsalves family and I only have become aware that there was a hearing on this matter from meeting with the Latah County Prosecutor's Office and investigators. Now, that's just why I underlined that, because what investigators? On February 8th, 2023, or we would have never known such hearing took place. So was this a slip up? Oh, wait, there was a hearing? Wait, but we're supposed to be notified because that's part of the victim's rights. The victims, you have the right to be at all criminal justice proceedings. You have the right to be present but it was a closed hearing. But we also have the right to be notified. Okay, for those of you guys that are wondering, in Idaho, just so we're clear here, even if these victims, so someone like a Dylan, a Bethany, and then you got all the family members, okay? A victim's right to be present should provide for the victim's presence during the entirety of the trial, even if the victim is to be a witness and the court concludes that the victim's testimony would be materially altered if the victim hears other testimony. Consider discussing with the prosecutor the possibility of the victim testifying first to best ensure the victim's right to be present during the entirety of the trial is not, fucked with. So again, gonna look at these. Tamara, welcome. Christy, Nevada, member for 6 months. Woo, baby. Miss Potts, 19 months. Best channel on the tubes. Dinky, love ya. Heather, I agree. Best platform, no drama, just facts. You know it. And I just do some random ass show yesterday for your guys' entertainment too. Good morning, Lana. And everyone else. Love you. 19 months. Why be so nosy? Boom. Curious Cat. Member for 12 months. That's a year, man. But now, if you want to read the whole 68 pages, go right ahead. I gave you the bullet points, but the title of this live, and I wanted to keep it right at an hour, is, and that's where it's going to stay here. Janet's just amazing, by the way. The title of the live is Why Would Somebody Change? What's going on? Something seems off. What do they have that we don't have? Everybody is out there. Oh my God, the Gonsalveses know so much more than we do. Trust me, they wouldn't be doing this. They know things. They have things. They've been told things. Well, that's great. That's your opinion. Okay. I went ahead and just wanted to look at some documents. All right. And a document worth looking at is that in order to get your claim in, you had to put it in within a year. And so I don't know if they did that or not, but you are going to fully cooperate with all law enforcement agencies and the prosecuting attorneys in the apprehension and prosecution of the offender causing the criminally injurious conduct. And if you don't, we may deny or reconsider and reduce any award of compensation. So this to me makes way more sense than, why I have to go along with, just complete incompetence. I can't say those things. If I say those things, I always felt that it was, you want to have that united front, but why? There's no way I would want to know everything. What would be holding me back to just saying whatever the hell I wanted, whenever the hell I wanted it? Well, and that, my friend, is over here. And that would have been, you had to file within 1 year. And then so go ahead and look up and see what is considered, what compensation can you get? What could it be for? And I would totally think that this is supposed to be in Latah County, right? And being told that, hey, if we dress Brian Kober a certain way, it's going to stay here. If the prosecutor is telling me all of these things, because this is how we're going to keep it here, okay? And then y'all don't keep it here, and you guys didn't even cross-examine people. You guys didn't do anything, right? Well, now I have to go to Boise. You don't think that I'm going to go to if I'm Steve Gonsalves, you don't think I'm going to go to the prosecutor and say, well, I want to attend this trial every single day. I'm putting in for this expense of all of this to be compensated because you guys didn't do your job. Or better yet, don't say you didn't do your job. Say, you guys promised me this. If you were promised it. You guys said there was a gag order because of this. So I would think that this would be some, that the state, you know, they couldn't talk about how hefty their bill would be if it does move out, all the people that we promised we're going to have to pay for all these, you know. Also, when you're reading through this, it does not, so even if there's third parties, again, you're going to have to show your here we go. So subject to the limitations on payments for the cost, like that stuff's just not even going to be look at this. Let me just read these. You got to stay out of trouble. You can't be, yeah. Anyways, thumbs it up, share the video. But this to me would be, it's just very interesting where this whole 180 could have came from. And I took us back to the beginning, and I want to thank everybody for being here as always. And then I think we're going to have the next live is going to be on, we're going to revisit these. Lana, it's a maximum of $25,000 to be compensated. I'll go take a look at that. But well, good job, Lana. A+. Well, thank you. I dig. I would say fucking shove your $25,000 up your fucking ass, and I want to know the truth of what happened to my daughter. And so I'm just saying, it could be totally, they didn't even apply for it. They were like, what? We didn't even know that. What if they come out and they say, oh, then I'd be like, well, then your victim rights advocate person that you're using is just a complete, fool. But your lawyer should know all that as well. So again, thumbs it up, thumbs it down. Let me know what you guys think in the comment section of the video. Very curious to hear your guys' comments. Go be educated, read up it yourself. If something that I missed, make it known in the comment section. Again, this is is it possible that the reason we've seen such a shift in, is it right here? So again, I want to thank you guys on your way out. Thumbs up the video. Thank you, moderators, members, subscribers. You guys are the reason I'm here.
Listen, folks, I know there's a history here. I'd like to get this hearing in today.
Please.
Everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you? Who's responsible here?
What's that?
Who's responsible here? Whose house is this? Yeah, been drinking or anything, right?
No.
Okay, drive careful, okay?
Will do, thank you.
This is what the other group had that ran away.
Oh, really? You just ditched it? Awesome.
Those ones kept walking in the car.